All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give your attention. God save the United States in this honorable court. This honorable court is now in session. Please come to order.
Good morning and welcome everyone to oral argument before the District of Columbia Court of Appeals. Because of the COVID-19 pandemic, our court has had to make a number of adjustments to allow us to continue our work. And we are hearing cases and deciding cases, but we are doing so solely remotely. So today, our oral arguments are being live streamed on YouTube, and a link to our arguments is available on the court's website. The court staff have worked very hard to prepare the judges and counsel to conduct remote oral arguments, but technical problems may still arise. And if they do, we will try to resolve them as quickly as possible, but we ask for your patience. We have three cases on our calendar today. We're going to ask counsel to introduce themselves when they begin their argument, and for appellant's counsel to tell us how much time they would like to reserve for rebuttal. So now we will hear our first case on the calendar, which is case number 19 CV 697, Ludwig and Robinson PLLC versus Biotech Pharma LLC. Can I ask anyone who is not speaking to mute their mic, please? Appellant's counsel, I understand that you are, Mr. Durrett and Mr. Kalin are splitting your time, so maybe you'd like to speak to that. Thank you. Mr. Jacobitz, sorry, you're muted. Thank you. But Mr. Ludwig, you are not. If you could mute yourself.
Mute myself, did you say?
Right, because you're not speaking now, right? Or are you?
I'm the appellant.
Sorry, you're going first. Sorry, we're splitting time for the appellees. I apologize.
That's right.
Okay, so go ahead, Mr. Ludwig.
Good morning, Your Honor. I'd like to reserve, given the multiple appellees, 6 minutes, please. This is a simple case. Despite a large record in 2 prior appeals, it's made easier because appellees avoid the relevant facts in governing law. It involves, quote, one of the gloomiest cases that I've ever handled, the trial court noted, questioning why an educated businessman would engage in a course that requires 3 incarcerations. The answer why appellee Gurgis would risk incarceration, as pled in our complaint in the year 2013, raised in the opposition below and in the opening and reply briefs, was Mr. Gurgis's refusal to disclose the marketing and sales activity of his saliva-based drug tests that our firm, Ludwig & Robinson, secured as former counsel for BTP and suspected for years, but could never uncover.
So counsel, I'm sorry, I don't think you told us how much time you'd like to reserve for rebuttal.
Oh, I'm sorry, I already said, I'd like to reserve 6 minutes, please.
Okay, and then jumping into the case, I mean, the facts of this case may be distressing, but it seems that much of the misconduct by the appellees was known to you before the settlement. So why is it that we should unwind the settlement if you knew more or less what had been done?
Well, as seminal decisions in the Supreme Court, the Hazel Atlas case that really set the modern standard for fraud in the court, and the recent 2017 unanimous Supreme Court decision in Hager made clear that even where there is knowledge of some fraud and suspicions of the exact fraud, that where the party is thwarted from uncovering the key information, that's revealed only after settlement. And both cases involved a settlement, and both cases reopened and devitalized the settlement. That the settlement was no bar to a remedy under fraud of the court doctrine.
I think you might have an uphill battle convincing us or convincing me that this was really the key information that came out post-settlement. I mean, you the trial court's June proclamation that this is one of the gloomiest cases you've seen, but of course that's 4 months before you settle the case. So it seems like the gravamen of your fraud of the court claim was known before the settlement, and what came up later, 2 days later, according to the proffer, is a bit of extra confirmation, but the type of thing that you tend to sign away when you settle a claim. And one claim that you settled here was a fraud of the court claim that you had already alerted the court you were planning to raise and had raised.
Well, what we understood as counsel and dealt with for years in this collection matter, what we sought as counsel to understand was whether our client had the ability to pay us. That was a problem ongoing during the underlying litigation, 2011 and 2012. And it continued for years. And the only basis we understood for them to cover our real attorney fees and then the costs as provided in BTP2, which remanded for the fraud and conspiracy claims, and then the years of chasing them that morphed into fraud in the court, was whether they developed an ability to actually do business and market and sell their key product. They hid that. They played a shell game for years. If you will, this Egyptian businessman.
Can you just explain to me why that's the key question? Why isn't the key question, did they have enough money to pay you what you thought they owed? And if that, and didn't you have plenty of information that they did prior to settling?
No, we didn't. We understood that the monies that was acquired by BTP came through basically stock scams, through a reverse merger into something called PCNT, and then other entities we uncovered over the years. And these were publicly traded entities. But we never discovered, and we were thwarted by repeated responses to discovery that there was no marketing and sales activity, and understanding whether this entity had a real capacity to pay. Beyond...
Can I ask you a framework question? Because if, as you were characterizing it today, the issue is whether this is the newly acquired information was key information. The trial court obviously didn't view it as that. And do you agree that we should be approaching in a deferential way, as kind of under an abuse of discretion or similar standard, the trial court's judgment that this really was more of the same of what you already suspected, rather than key information that required the trial court to set aside a settlement agreement that had been entered into? Do you agree that we should approach that ruling deferentially unless we find some clear error of law that infected it?
Well, no, I do not agree with that, Your Honor, for this reason. It was not a discretionary decision. The court ruled below on very cursory analysis, in fact, no analysis, as to the after discovered fraud case law, that no new information, key or otherwise, would be sufficient to reopen the case.
So that's not how I read the trial court's ruling. So why don't you give me your best shot of where you think the trial court says it doesn't matter what this after discovered fraud would be, it would never be enough. Whereas I read the trial court to say, this is basically the same complaint you've been raising for years. Is part and parcel fraud in the court claim that you have been bandying about for a while. That's how I read the trial court's ruling. So convince me that I'm wrong.
Well, I believe at page 17, let's see.
You're on the December 7th order, right?
Yeah, 1797, the court just said, to the extent that any conduct by defendants satisfied the elements of fraud, Plaintiff was well aware and argued as much in open court. And then it's cited to the proposed motion for fraud in the court. But we made clear in that motion what we knew previously in the Section A of the Statement of Facts and a Section B, which was newly discovered as revealed by the whistleblower. The distinction, and the court didn't focus on the distinction. It just made a blanket ruling that no amount of newly discovered fraud, having pled and argued fraud before, would allow the court to consider.
I'm just going to ask for it again. Give me the closest thing. So I know you said 1797. Are you looking at page 17 of the December 7th ruling?
Page 18 of the,
Page 8, yeah, the to the extent paragraph.
yes.
And what in there says it doesn't matter what it was or if it was a different type of fraud. That's not how I read it. So highlight for me what you think says what you just said.
Well, it says in the middle of that paragraph, quote, it follows that the proposed motion for fraud in the court was accounted for among the disputed matters that were resolved through the settlement agreement. The court is not parsing the nature or quality of the new evidence at all. It's just ruling as a matter of law.
I mean, it seems like a really uncharitable reading of this where, you know, thinking in context, it seems to be saying, me, this is the same thing that you guys were complaining about before reaching a settlement to resolve those claims. That's so I don't see a ruling of law here just yet. I'll keep looking at it though.
Well, Your Honor, when you say it's the same thing, the court is referring to fraud in the court, i.e. the whole basket of fraud in the court, regardless of what's in the basket.
Counsel, can I ask you, let's say we agreed with you. I mean, I take your point that the trial court could have explained more and could have said, look, here were the allegations of fraud that were known, on fraud on the court that were known at the time of the settlement. Here's the new information, and let's compare it. And actually, when you look at it, it's really kind of more of the same. So the discussion could have been more concrete, which is often true. You can always say more. And it seems to me, though, that if that's the only problem, at most what you would get would be for us to send it back and say, Judge, you need to explain some more, unless you think that the judge couldn't have written an order that would have said, you know, along the lines of a more expansive order that would have said in more detail, look, here was the previously known fraud information, here's the new information, or known or suspected, and here is why I think it's just kind of more of the same and not key. Do you think the evidence would not have allowed the trial court to have written appropriately, permissibly, an order that in greater detail compared the two and just concluded not key information, really more of the same? So you want relief from us outright. This should have been set aside as a matter of law. No reasonable fact finder could have reached a different conclusion. Is that right?
That's correct, Your Honor. And we reviewed in our reply brief, particularly the facts of Hazel and Hager, where we go through just what was understood and what was new, and how the plaintiff did not know the material and pertinent facts prior to in this case, the whistleblower.
And if you were going to say what's critical about the new information, I know that there was one of the big pieces was the idea that one of the BTP entities, although it had been alleged to have not been very, inactive or something like that, was in the process of or had made a bid on, on a valuable government contract. I mean, that definitely shows if believed, it shows that there was activity where it was denied. It doesn't necessarily by itself show that there was an actual pot of money that was being hidden. It might point you to further concern on the topic. But so I know that piece. And then what else could you be just very concrete about what you think the whistleblower information was that was kind of game changing, revolutionary relative to the suspicions and concerns that you had already been litigating very actively with a lot of success in front of the trial court, in the sense that the trial court was persuaded that there was a problem, was granting relief. You hadn't yet chased it all the way down to a judgment you could enforce against other entities. I get that, but what was revolutionary about this new information?
Well, the whistleblower exposed the myth, the deceit that the two BTP entities, one BTP Corp was alleged to be and BTP itself was alleged to be inactive, were in fact very active with marketing sales. And from our perspective, we were seeking to recover the full quantum of our outstanding legal fees. And if we understood that these were ongoing operations and had the potential, even in the future, we could have done a structured settlement for more recovery of these fees. Otherwise, we were just left to the pretense that, and look at the structure of the settlement, BTP did not contribute a single dollar. Allegedly, it's all investor money. It's $300,000 from Applee Kalin, and then $900,000 from a Texas investor. That was the pretense, that BTP at that point was all an investment scam, or it was had no ability on its own to generate funds. That's what was new. That's what was exploded by the whistleblower.
But I guess I'm wondering why, given what you knew before the settlement, and really given your history here, I mean, your tenacity and your doggedness in pursuing them all these years almost sort of undercuts your argument now. Why you couldn't have negotiated the structured settlement that you're saying you would have negotiated had you had this new information, right? Why you couldn't have negotiated that provision of, hey, if there are some marketing efforts or there is some pot of money that we don't know about now, but we still suspect that you have, we want a cut of that in the future if it exists. Why couldn't you have put that in the settlement?
Well, we attempted to, and all we managed to get was basically to the award, the arbitration award, plus outstanding fee awards, interest, and a small increment over that. But that's the best we could do.
Which way does that cut if you actually asked for it and didn't get it?
Well, no, we did not ask for what we would have asked for 2 days later after the whistleblower.
Right. And so my question was, why couldn't you have asked that before, knowing what you knew, from your perspective, right? You couldn't trust these people as far as you could throw them, right? So from that perspective, why didn't you negotiate a better settlement with this structured provision for, a payment if sudden profits materialized?
It just wasn't possible. And it would not have been possible until we had exposed the lies with respect to marketing and sales.
I just have one question on ratification, or what might be referred to as, the tender back doctrine as well. Let's assume we agree with you on the substantive point. Are you prepared to tender back the $1.2 million that you accepted in the settlement?
Well, I think under pretty basic contract principles, there's no obligation to tender back. We set forth why, and
yeah, but let me give you two issues with the exception that you're citing to. One is, at most, you are clearly entitled to something north of $900,000, not the full 1.2. So it doesn't get you all the way home. But the second problem with you citing that is this money wasn't coming from Biotech, who owed you that money. It was coming from Loudermilk and Kalin, I believe. So there's no question in my mind that you weren't entitled to that $1.2 million from them, so that if you wanted to rescind an agreement, you would have to give that money back to them. If you even wanted it to be considered, you might have to give it back to them under the restatements position. So, I don't think you answered the question. Is that something you're prepared to do?
Again, we don't see the obligation to do that. Basically, the investor was an agent of our contract party, our former client, BTP. It was a volunteer. It advanced the funds. And for the reasons stated, it had a business interest in BTP.
Counsel, I appreciate the legal argument, but mine is just kind of a factual question. It's kind of, what is your request for relief? Yay or nay, if the bottom line were, okay, you can pursue your fraud on the court claims, but you have to tender back the $1.2 million. Is that a disposition that you want or don't want?
Well, we want the relief that was granted in Hager by unanimous Supreme Court, which is to not return the settlement funds, but to award the plaintiff the increment in the form of attorney's fees and costs incurred by the fraud of the court. And in that case, it was to make the plaintiff whole. And as Justice Kagan indicated, it could be awarded in one fell swoop from the time that the fraud in the court originated. And in this case, it's back in the spring of 2015. So a simple remand would be to vacate the judgment with instructions to hold a damages hearing on what that quantum of fees and costs would be. And
Just to be clear, though, you are not seeking then reinstatement of the fraud counts, the other counts that were dismissed.
We are seeking that they be reinstated. The whole judgment needs to be vacated. We can negotiate separately with Mr. Kalin if he wishes. But in terms of BTP having committed fraud in the court, as well as LNR, there ought to be a remand with instructions to make the plaintiff whole. And that's what the case law, it seems the governing case law in this situation at the Supreme Court would call for.
All right, if my colleagues don't have any other questions at this point, let's hear from appellees.
Thank you, Your Honor. My name is Jeffrey Jacobovitz. I represent the appellee Martin Kalin. And the appellees have divided up the time in half between Mr. Durrett and myself. Mr. Durrett, who represents the BTP appellees, will address the fraud and unclean hands issues raised by appellant. I will address the issues related to the precipice and the binding settlement and acceptance of the $1.2 million and the failure to return the money, which the court has just raised in questions to Mr. Ludwig. And I might, before I even begin, I have to tell you, I'm somewhat bewildered because there is no judgment against Mr. Kalin, and there's no proof of fraud against Mr. Kalin, and there's no allegation that Mr. Kalin engaged in any fraud on the court. Yet we were forced to file a brief in response to Mr. Ludwig's brief. In his reply brief, he says he's not trying to unwind the settlement. He's just seeking damages, which is what he just told the court now. But if he's seeking damages, none of them would be against Mr. Kalin. And Mr. Kalin has already settled and been released. He paid his $300,000, even though technically he didn't owe anything. He was never found liable of anything. And he's not liable for any future damages. So I'm not sure why we're here today. And in fact, Mr. Loudermilk's in a similar position because Mr. Loudermilk paid $900,000. And I will go through briefly my arguments, Your Honor, but for the first time we heard in Mr. Ludwig's reply brief, and there was no place in the record for that he's not seeking to unwind the deal. He's really just seeking damages in a hearing and to remand it back for damages. Your Honors, the appellant contended that there was a staged settlement conference and that we used the trial court as an unwitting tool to achieve an undervalued settlement. Nothing could be further from the truth. Two separate trial court judges have already rejected appellant's efforts to unwind the settlement, including the judge who mediated the proceeding. Kalin and Loudermilk were not involved in any post-judgment discovery. Appellant does not allege that Kalin or Loudermilk perpetrated any fraud or inducement of fraud on the court relating to the post-judgment discovery. At the hearing, both parties accepted the court's offer. And when Mr. Ludwig indicates he didn't have a chance, this went back and forth with Judge Hoban. He mediated the settlement. We sat in his chambers. We went back and forth for quite some time. There was negotiation back and forth, and we reached an accommodation and we reached a settlement. And in fact, the $1.2 million was Mr. Ludwig's request at the end. None of the appellees who are here today made any representation at the settlement conference regarding the BTP defendants' ability to pay. And Mr. Gurgis did not at all, and Mr. Durrett will get into that. The settlement was confirmed by the written precipice. Days after the settlement, and while the parties were working to convert the precipice into a more formal document, the appellant claimed fraud and tried to pull out of the settlement or ask for more money. And I want to remind the courts that this case is probably one of the longest in the history of the DC Court of Appeals. It's now on 9.5 years. And then Ludwig turned around and asked for more money. And we rejected that demand. It went back before Judge Holman, and Mr. Ludwig allegedly had spoken to a whistleblower. He didn't produce any evidence whatsoever about this whistleblower. There was no sworn affidavit filed by the whistleblower, and Mr. Doretta will, respond to that as well. But Judge Epstein then, who took over the case when Judge Holman retired, but went on senior status, provided clarity with his orders. And Ludwig and Robinson never returned the money, nor did they release the liens on the patents, despite agreeing to at the mediation with Judge Holman.
Okay,
And I
counsel,
might add, he's seeking damages, but everybody signed releases here. And Mr. Ludwig and Robinson signed releases, releasing attorneys, releasing the defendants, and so
Okay.
forth.
I just want to start with a legal question.
Sure.
Do you agree that if the trial court said no amount of post-settlement fraud on the court, even if it were, game-changing, even if it were key and critical, and drastically inflated what they had previously known, would it be a correct statement to say even that would not be a basis to set aside a settlement? If that
I agree in this instance, Your Honor, that it would not be a correct basis to set aside the settlement, because for years, Mr. Ludwig has pursued Mr. Gurgis.
But assume not. I mean, the hypothetical is, assume he had only an inkling of some hiding assets, and then it came out the day after settlement. So just a different factual scenario that, in fact, biotech had, $30 million stashed away in a bank account. And previously, all he knew was, somehow he's paying his kids' college tuition without assets. So really a lot more comes out post-settlement. As a matter of law, if Mr. Ludwig is correct that the trial court said no after settlement fraud on the court could unwind a prior settlement, if that was in fact the trial court's ruling, do you agree that would be wrong?
Your Honor, I think you would have to, it's a hypothetical, but if you look at the facts of this case, where first of all, the contract that Mr. Gurgis allegedly bid on, he never received.
I'm sorry, I'm going to interrupt you one more time.
In other words, if there's
I'm not going to get an answer to that question, counsel. I understand it's a different case. That's why it's a hypothetical. But if I don't get an answer to that question, the follow-up question is, convince me that we're not in that scenario. Tell me why these 4 extra facts that came out from the whistleblower 2 days later aren't game-changing.
As a hypothetical or as specifically?
No, that is, now we're into the facts.
Okay, so the reason it's not a game changer is Mr. Ludwig pursued Mr. Gurgis for years. And he knew of fraud that was committed allegedly by the BTP defendants. So any new fraud that he learned of shouldn't have been a surprise to him. Mr. Ludwig represented to the court that he's had 35 years of experience negotiating settlements, and it's in the transcript. It's not like he's a rookie out there who negotiated his first settlement here. So he's aware fraud was committed before. He then alleges this whistleblower came forward, but none of the representations were made by Kalin or Loudermilk or by Mr. Gurgis. There were no representations in court. The settlement, by the way, Mr. Ludwig ended up with more money than he was awarded by the DC bar. None of the representations had an impact on the settlement because he ended up walking away with a lot of money. And so it was really, remorse on his part that he came back and tried to unwind the settlement, if that's what he's trying to do, although today it's not so clear what he's trying to do. And I think legally, it would not make a difference in this instance. So with respect to the affirmed and ratifying the agreement, Your Honor has asked questions regarding that to Mr. Ludwig, but even assuming the argument that the settlement agreement is voidable due to fraud, because appellant has affirmed and ratified the settlement agreement based on his demands saying that there was an impasse, he asked for the money. We wired the money once Judge Holman ordered us. It didn't order us to. What Judge Holman put it before us that we could either wire the money or just go on with the case. He didn't specifically order us to pay. We believe that LNR, the appellant, has accepted and retained the settlement proceeds and thus ratified the agreement. And in fact, today, Mr. Ludwig would not even tell the court whether he wanted to or had the ability to return the money, which is what the cases hold. The cases are clear that at this point, if the settlement is unwound, that the money should be returned. He doesn't want to do that. He wants his cake and eat it. He wants to keep the money and then have damages awarded. And if damage is awarded, it shouldn't be against Mr. Callen because he obviously wasn't part of that. And he didn't even put the money in the court registry. He continued to pursue the appeal. He seeks the benefits of the agreement without undertaking its obligations. And he should be precluded from attacking the validity of the agreement. Mr. Ludwig is seeking an extraordinary remedy here, avoiding a settlement agreement. And that shouldn't be upheld by, that should not be ordered by the court.
All right, counsel, I think you have used your time and we will hear from Mr. Durrett.
Good morning. May it please the court. Excuse me, I seem to have a frog this morning. My name is Wyatt Durrett and I represent the BTP defendants. My assignment this morning is to address the fraud, both the allegation of fraud on the court and fraud in the inducement and the doctrine of unclean hands. Let me do it in reverse, excuse me, of what I had previously planned. There was no order of specific performance, so unclean hands doesn't apply. There was no fraud on the court because the fraud was committed between the parties in the discovery process to try to locate assets in order for Ludwig and Robinson to be paid on their judgment. Fraud between the parties that doesn't affect the integrity of the court, of the ability of the court to function objectively, is not fraud on the court.
Can I ask you, counsel, how far you take that? Because this seems, I mean, I get that point if, you know, there's a request for answers or responses to interrogatories, and then someone says something that later turns out to be inaccurate, and really the court isn't called into the topic at all, and then later someone alleges there was fraud on the court. This case was somewhat different in that it wasn't just that there were allegations of incorrect information being fed back to the opposing party. The court got involved, and the court ordered your client to do. I guess if all the BT associated entities, including Mr. Georges, are your clients, then at least one of the BTP related folks, according to the trial court, refused to comply, had to be criminally, incarcerated as civil contempt. And that did involve the court in all of what the court viewed as a pattern of deceptive and obstructive conduct. So the point that you're raising, relying on cases about kind of run-of-the-mill discovery disputes, seems a fair bit removed from what happened here.
Well, respectively, Judge McLeish, I don't think it is with respect to whether there was fraud practiced on the court. There's no question that the court was intimately involved. No question that it found Dr. Georges in contempt. It put him in jail 3 times. The court had all of this in front of it, but Judge Holman did not feel he had been defrauded. And in response to your earlier question, I think it is an abuse of discretion standard, and I think you do approach it with deference.
Can I ask you, you're saying where in Judge Holman's order do you, I mean, you mean defrauded in connection with the settlement, or that there hadn't been antecedent fraud on the court? Because some of the points you were making are about whether there was fraud on the court before the proceedings, directly surrounding the settlement negotiations and agreement. And that was, my question was more about that part. And are you saying that you think Judge Holman said somewhere he didn't think anybody had ever defrauded the court in connection with this litigation? Or was Judge Holman's implicit view of that more narrow and focused on the settlement agreement negotiations themselves?
I think it was more implicit, and as I believe you said earlier, Judge McLeese, he could have been perhaps more elaborate, but I think it's clear from what he did say that he did not feel that there had been direct fraud practiced on the court. And
just to be clear, you mean at any point,
at
not
any
just
point,
like sort of in connection with the settlement, at any point?
at any point.
Where would
And
you point to in anything Judge Holman said that would run that far? Implicitly,
his order, on
I got that, but where in the order?
just a second. His the order that he entered, which addresses when he upheld the settlement agreement in December of 2018, in that order, I believe that he implicitly understood that no direct misrepresentations in the 3 years, in the 3 preceding years, had been made to him. And in
See,
fact,
I read his order the opposite. Well, not 180 degrees opposite, but maybe 90 degrees orthogonal to that. I mean, the paragraph at issue, the to the extent paragraph on page 18 of that order, says talks about fraud generally in its first sentence, and then it says the plaintiff argued there was fraud on the court, and what Judge Holman says is not, no, there's no fraud on the court. I have no reason to be concerned about fraud on the court. What Judge Holman says is it follows that the motion was accounted for among the disputed matters. So I didn't take Judge Holman to be implicitly ruling there had been no fraud on the court, but rather to say there's an allegation of fraud on the court. I don't need to sort that out because everybody was aware that that was an allegation and it was taken care of as part and parcel of the settlement. They, you know, the Ludwig firm kind of settled that issue away, so I don't have to decide it. That's more how I had understood Judge Holman's order. But I gather you think Judge Holman implicitly was saying, you know, nothing that any of the BTP related folks did in my court, even though I held, you know, one of the principals in jail 3 times amounted to fraud on the court. You think that's implicit in Judge Holman's order?
I think it's implicit, Your Honor, because of the language that he chose and the language that you read. He said the proposed motion for fraud on the court was accounted for, the proposed motion for fraud on the court. I think that Judge Holman realized, and if you look through these briefs for any citation to an actual material fraud on the court, there is none.
Can I ask you another, a legal question? Let's assume that Judge Holman said that, or in any event, we're discussing whether that's a correct legal principle or not. So if the issue is, you know, party A, let's say, intentionally lies in discovery-related matters to the opponent, party B. The party B believes that's a lie and invokes the process of the court and gets the court to, you know, order party A to tell the truth, reveal the truth, provide additional information. And party A refuses, rejects all those court's orders, is unwilling to comply with them, and has to be incarcerated in civil contempt. If the issue is that fraud on the court, like what case would you point us to, or what would your argument be about that, why that isn't fraud on the court? Is there some case that looks like that says it's not fraud on the court?
I don't think there's a case directly on that point, Your Honor, but the 2 cases that we relied on in our brief, Oliverius versus Stanley J. Sarnoff and Partnership Placements versus Landmark, Inc., the language that the court uses, for example, in the partnership placement case, fraud on the court is fraud in which the integrity of the court and its ability to function impartially is directly impinged.
And why would that not be the case if the court is tasked with fairly resolving a dispute between the parties? One of the parties is intentionally lying to the other. The court tries to use its authority to fix that problem, and the contumacious party refuses to do so, even after having been thrown in jail multiple times. Why would that not fit quite comfortably in the language you're describing?
Your Honor, respectfully, I don't think that goes to the integrity of the court or its ability to function impartially. The court is functioning under those circumstances precisely as it is supposed to. The issue has been brought to it. It understands what the issue is. There's been no fraud practiced on the court. and it's exercising its full powers in issuing sanctions, awarding attorney's fees as Judge Holman did. That doesn't constitute fraud on the court. The court is functioning impartially and doing what it is supposed to do.
Even though its orders are being defied under Judge McLeese's hypothetical. So I guess you're distinguishing between fraud on the court and contemptuous activity.
Judge Easterly, exactly. That's what I'm distinguishing between. The fraud on the court standard is deliberately high. Even perjury doesn't meet it in the Oliverius case. So,
And can I ask you, is it your position that if we went back and looked carefully, we would find no place in which any of the BTP related entities or individuals, while there was all this dispute going on, made representations that the court later determined were false to the court directly, rather than in interrogatory responses that were initially to the opposing, that were to the opposing party? That's your view? Is we just couldn't find anything where some of the BTP related entities in effect made intentional false statements to the court.
Judge McLeese, let me answer you directly this way. I was not counsel in the trial court. Mr. Jacobovich was, but I did comb the record and I looked as intently as I could to find something that was directly a fraudulent misrepresentation to the court in some material fashion, and I could not find it.
Thank you.
I would defer to Mr. Jacobovich if there's any time left, because he would maybe be more knowledgeable on the trial court record than I am.
Yeah, I would actually defer to Mr. Wilson, who was the prior counsel for Mr. Gurgis and the BTP defendants, because my client was not part of any of the post-discovery disputes.
So I guess the answer, Judge McLeese, is I couldn't find it.
All right. Thank you, counsel. We'll certainly take a look at the record again. I think unless my colleagues have any other questions for the appellees, we'll turn back to Mr. Ludwig. You're muted, Mr. Ludwig.
Thank you. I'd like to address the last point first as to whether there's anything in the record. The record is replete with misrepresentations made to the court directly, as well as the adversary, our firm. This is not a case of just non-compliance that was dealt with by contempt remedies. This is not a case of mere discovery abuses as downplayed in appellee's briefs. This is not a case of misrepresentations solely to the adversary. This is a case of misrepresentations and lies repeatedly made through a systematic fraud in the court to the court itself.
Mr. Ludwig, you say the record is
Go
replete
ahead.
with that. Is there a place where you would want to pick your best example and point us to it in the record?
I believe at pages 46 through 47 of Helen's brief, we document how Mr. Gurgis and counsel Wilson repeatedly misrepresented the facts to the court. And for example, there's a June 2015 affidavit that Wilson submitted on behalf of Gurgis. 3 months after Gurgis had done a reverse merger to acquire 36 million shares, $360,000 salary from PCNT, where he misrepresented to the court, as well as us, that he had no assets and he had kept Eleanor fully apprised of his financial condition.
Do you want to try pointing us to anything that's post-settlement?
That's post-settlement, excuse me?
Anything that didn't precede the settlement?
Well, the last representations basically just in effect the day before settlement. And that's because the defendants received these 11-month stay, would be from December of 2017 and January 2017, where sworn interrogatory answers reported that BTP Corp was defunct and BTP itself was inactive. They were counsel and submitted as ordered to the court for monitoring. And they were followed up by a precipice filed by counsel the next month in January, saying that those answers had been fully answered. And this also followed a long history where there were 4 affidavits that were false, submitted by counsel and Gurgis himself, claiming that Gurgis had not a penny to his name, when in fact, in post-appellate motions practice, Wilson admitted in effect that he had suborned perjury. He knew as of September 2015 about the existence of PCNT, and yet he filed his own affidavit and that of Gurgis a month later to the court that Gurgis did not have a penny to his name. And this continued throughout the litigation. These are misrepresentations to the court itself.
I do suspect, I mean, my memory is that when I look at the record, you were saying that was false long before you settled.
Well, yes, but that's with respect to having a penny to his name. They didn't address, and they never would address, whether there were marketing and sales. And that's what distinguishes the Section A part of our 70-page motion for fraud in the court and the Section B. And Section B is very focused on the marketing and sales deceit. I'd like to move to another
Does
point.
your fraud, I'm sorry, just one question that maybe I should have asked at the very beginning of the argument. Does your fraud on the court argument necessarily indicate that you expect that the court should have or could have done something differently had it been told the truth? Right? Is it premised on some argument that the court should not have facilitated the settlement, should not have permitted the settlement to go forward?
If the whistleblower had appeared before the settlement, that's correct. The court would have had, in our view, a duty, an obligation to
Independent of you all, independent of Ludwig and Robinson, even if you all had wanted to settle, the court should have said, no, I can't allow this to go forward because this is, the foundation for this is just pure lies.
Well, no, it could have allowed a settlement to go forward as part of a remedy, but the remedy for fraud in the court perpetuated by defendant is not dismissal of the action, which occurs with the plaintiff. It's a severe remedy in that case. The severe remedy would be monetary damages. And that's what the court could have crafted. It has an independent duty apart from what the litigant seeks to unearth, to investigate, basically an affront to the judicial system, to the court itself. And we raised that point in our appellant's brief, that not only did the court not listen or entertain as properly as we think it should have our application, it should have been doing that itself after we raised it.
All right, counsel, you're at the end of your time if you want to quickly wrap up.
Just with respect to specific performance, that unclean hands is not applicable. In fact, outlined at page 1790 of joint appendix in his omnibus order, the elements of specific performance and unclean hands, and then he entered an order enforcing the settlement pursuant to motions to enforce. Clearly, the equitable doctrine was applied. Unclean hands is not immaterial as defendants baselessly claim. And that's another alternative. It's an akin to fraud in the court, as this court recognized in the Synanon case, applying the Kaiser, the Keystone Driller case of the Supreme Court. It's another remedy here that we ask be applied.
All right, thank you, counsel. The case will be submitted. We appreciate your time today.
Thank you, Your
Honor.
The next case on our calendar today is 18 AA 1146, James Fournier et al. Versus DC Zoning Commission. My understanding is that there are a number of joint petitioners, but only Mr. Otten is arguing as a petitioner this morning. Is that correct?
Your Honor, can you hear me?
Yes.
Hi, my name is Chris Otten. We were told yesterday that the rules, just
I'm sorry, Mr. Otten, you've frozen for a moment. We seem to have lost connection with you for a moment. Mr. Dickerson, I wonder if we could get Mr. Otten to sign off and then sign back on.
sign off and sign back on? Okay, I'm
Well,
sorry.
I'm not sure what's quite best, but it seems like your internet is not functioning, is not streaming fast enough to allow us to see your video and hear your audio.
I see. I'll do that right now. I'll sign off and sign back on.
And maybe check your internet connection. Thank you.
Okay.
Mr. Dickerson, I don't know, maybe Mr. Otten might try and reach you separately to troubleshoot if he
Okay.
has any problems. Okay.
Okay, thanks, Your Honor. We'll see if he comes in. Now I'll admit him back in. Thank you. Your Honors, I did give Mr. Otten, I gave him a call and he's still trying to get back in. So I'll let you all know when he comes back in.
Okay.
Thank you.
Is this better now?
Yes, I think that this looks good. Let's give it a try. So we're calling again the case 18AA 1146, James Fournier et al. Versus DC Zoning Commission. We have a number of joint petitioners, but my understanding, Mr. Otten, is that you were speaking for yourself today, and then we'll hear from the Zoning Commission Council. So if you could introduce yourself for the record and then tell us how much time you'd like for rebuttal.
Sure. Again, my name is Chris Otten. I'm one of the pro se plaintiffs. I'm hoping to present for no more than 10 minutes and reserve 5 minutes for rebuttal.
Thank you. Go right ahead.
Thank you. May it please the court. My name is Chris Otten. I am one of 7 appellants in this case. We have before you a review, second stage zoning review of parcel 2 of the, of course, very controversial McMillan redevelopment proposal that's been on the table now before this court in a first stage review. 3 key elements of our appeal center in on transportation impacts such as on the environment and about the affordable housing. Critically here, parcel 2 is a 7-story building with almost 230 units for people to live in. It's called a multi-family building, although there isn't actually one family-sized 3-bedroom unit in it. And also, it's got 220 parking spaces, so almost a 1-for-1 parking to person or unit ratio. The commission describes parts of the issues around this as it's going to be tight there on a new street, 3/4 street that is parallel to First Street. The site, of course, is very close to the McMillan Reservoir, right across the street from parcel 2 on this overall 25-acre site that is. And so we really wanted to zoom in, if you will, to the zoning regs that talk about the second stage review, particularly 11 DCMR 2402.2 B and 11 DCMR 2406.12. The applicant intervener, we know in this process, is really trying to have the least amount of conditions put in the order associated with their project to build their project. Now we have an Office of Planning and the structure of the Zoning Commission to uphold the statute to protect the residents of the Columbia District of Columbia, particularly DC Code 6-641.02. Is the purpose of zoning is ultimately put an arm around the community and the neighborhood of safety. Now, during the second stage review, many folks testified at the hearing to ask the commission to more closely examine the 2 sides of the coin that the commission is supposed to look at, benefits and impacts. And here they understep both. The commission steps their authority to look at benefits specific to parcel 2 that are part of the overall benefits, and the impacts from parcel 2 that are part of the overall impacts. Now,
Mr. Otten, can I ask you a legal framework question and kind of what your position is about how stage 2 works? Because as you're describing it now, you're painting a picture where the obligation of the zoning commission when it's approving a second stage application is to kind of look at it again, like a second look. And, but to, look at it with new eyes and not be kind of bound by whatever it did before and say, now we're now at it's kind of a separate proceeding and someone is raising a variety of concerns and now the commission kind of needs to look at them anew. And the commission, I think, took the view that its function at the second stage was different. And that if if someone comes in at a second stage application and objects and says, I have general concerns about the balancing of interests and the like. So, consider that now, zoning commission. I think the zoning commission took the view that the zoning commission doesn't really need to do that at the second stage. If the issue has already been teed up and been decided at stage one, stage two is really more about what's new, what's more specific, how have the plans become more detailed. And I'm wondering whether you agree or disagree with A, that's kind of what the zoning commission thought it was doing, and B, whether it's okay for the zoning commission to take that approach or whether the zoning commission really does need to kind of look at it again and rethink it now that we're at stage two and consider these points, even if they had been the topic of the issues in front of the commission at stage one.
Okay, pointedly, we don't think it's a new. So it's not a de novo sort of review of all the issues and everything. The second stage, as cited in the regs, is a specific view. So where stage one is a general overall approval of, I like the analogy of the first state, the overall project is the feast, if you will, planning for a feast. What do we have to get for all these ingredients for the main course, the appetizers? Let's say parcel two is the cake, of the course. What are the ingredients for parcel two? What are we specifically doing in parcel two to make this overall, to live up to the overall benefits of the feast? Now, what the commission did here is, in the first stage, discuss overall benefits. If you look at the zoning order in the first stage, the corrected one, they talk about the project will contain 288,000 square feet of landscaped area, 12,000 square feet of bioretention facility, 750 new trees, 11,000 square feet of green roof. Now, the question here is, how does that relate to parcel two? Where are those benefits that were touted in the first stage relevant in parcel two? We do not see that analysis on here. How much of parcel two building will have the tree, the green roof, the solar? When we ask,
can I ask you a question? Let me just be a little more concrete, taking one of the issues you raised, which is traffic, and just to see what part you think is sort of the main course and what part is more the, to use the analogy you're suggesting, more like a dessert or a side dish that is still open for discussion. So let's say that in trying to decide whether to approve the stage one application, one of the issues that's raised is the effect of the overall development is going to be to create serious traffic problems along North Capitol or Michigan Avenue or in various places. And imagine that the commission hears from both sides and it ends up explaining why it thinks that that's not a problem, it's going to be adequately mitigated. And there's litigation about whether that's an adequate explanation. At the end of the day, the Court of Appeals says that was an adequate explanation, so we're upholding that aspect of the stage one approval. Right. And then imagine that someone comes in, when you get to the stage two application, someone says, okay, here's what this building is going to look like on parcel two. If the objector comes in and says, you know what, I'm still really unhappy about the fact that there's going to be a lot of traffic that's generated by this project as a whole, and of course this building is going to be contributing to it. And so, commission, you need to think through and address this question of traffic in it, and that's part of this piece of cake, because this piece of cake is contributing to that traffic problem, not in some new or unpredicted way necessarily, but it's just, that's part of the impact of this project. Is that something that the commission would be required to address in detail, or could the commission, if those are the circumstances, say, unless there's something different than what we were expecting about this building when we approved the overall plan at stage one, we don't really need to rethink traffic. I know there are some differences you try to point to, but I'm just trying to get the overall framework, because part of what the commission said about the objections you were raising was really, I mean, in the vernacular, kind of been there, done that. We thought this through in approving stage one. And so in the example I gave about traffic, you think the commission does have to think through at the stage two process based on a new record in front of it, whether on balance the traffic impacts of the overall project as contributed to by building two are mitigatable or not?
Yes, it's important because again, in second stage, they're not relieved of finding relevancy to the comp plan. And we know the comp plan talks specifically about transportation. We cited a few of the key comp plan policies in our brief. But, it says transportation has always played an important role in Washington's security by providing a means of evacuation and for emergency relief services. The city must continue to plan for and safeguard its transportation system as a major right of the economy of our city. So here again, what you see happen is in the corrected order of the first stage, that thanks to this court allowed the commission to re-review what they did in the first stage and say, actually, yeah, transportation is going to be bad. We're going to have to do something about this. Here are some ideas, and DDOT presented some ideas. I think there was some additional stoplights and stop signs. So now when we get to the second stage and zoom down a bit to specifics as required by the regs 2402.2, I mean, a specific analysis here. Where are those stop signs going? Where are the stop lights that were referred to in the first order? Where are they now actually here in parcel 2? How are they actually performing their mitigation, right? What we see the commission do, they do some things that get into the detail around transportation. They do set up a condition where the loading dock, for example, have a loading dock champion that's going to be waving flags or helping the trucks kind of navigate what is going to be very narrow 3/4 street. That was a very specific, detailed condition that came out of the second stage flood review. We brought up other specifics that we think are important, such as how are we going to protect these historic silos that are now going to be hitting right smack dab in the center of a new road that serves parcel 2, with all the trucks coming and going. How are the people in the people in the district in this overall site during an emergency response time, knowing we already know from the first stage that the degradation, the level of service degradation of the transportation system is already failing. How are we going to make sure those 200 units, in addition to all the other units in the area, are going to be served well by the emergency services that we have now? We need.
Can I ask you about one other specific point you raise in this court, which is about the requirement in, I think, both of the two first stage orders that there be an update in the second stage applications of the implementation of the transit implementation plan. I know that's a point that you make in your brief in this court, and I did have a procedural question about it. So I wonder if you know the answer. Is that there is such a requirement, and that the second stage application was lacking it? Is that something that someone specifically mentioned to the commission during the second stage proceedings in this case, or is that something that is specifically being mentioned for the first time in the briefs in this court?
You know what, Your Honor, I'm not quite sure. I'll have to look at the record again. I know certainly we raised traffic as a contested issue below during the second stage review. Now, we're not experts, right? No, we're not lawyers, but we're trying to participate in pretty arcane stuff here. But it's clear in the first stage order, it says unequivocally, the applicant shall provide the commission with an update of its transit implementation plan with each second stage PUD application. They did not do that here, and they should know. I mean, the intent of the second stage review is to make sure it aligns with the first stage, right? And so that was not done here. This is the transit implementation plan is like how are these 200 units now going to merge in with the existing transit systems around the site? Do we need more buses? Do we need more shuttles, things like this? That all was discussed generally in the first stage. Now we're talking about real people living at parcel 2. How is this going to work for them? How is it not going to further burden the existing transit ways and the people who use it now in the community like us? These are important things. You know, the environmental issues as well. I mean, the sustainability plan is specifically talked about by the Department of Energy and Environment. And it talks about how we need to bring much more solar into these projects and green roofs. There is no analysis. How does parcels 2 building meet vis-a-vis these goals and objectives of these planning policies?
Right, and I think the
not
commission's
occurred
view
here.
about that, about environment, seemed to be, paraphrasing, that there was very detailed inquiry about exactly what the environmental issue, attributes of the buildings were going to be at stage 1. And it was in fact specifically indicated that building 2 would be silver, at the silver LED level. Although there was some indication it'd be nice if the interveners would be able to upgrade it. That the project as a whole would be LED gold. And so the commission's view, I think, seemed to be, we were pretty detailed at stage 1 about exactly what we were going to require of this building and the plan overall. Nothing has changed except as it might relate to traffic. Primarily, the building is smaller. The number of people, it's going to be short, fewer stories, and significantly fewer, smaller number of square feet. So I think the commission kind of again thought there's nothing more we need to do here than what we already have done. We already pretty specifically reached a conclusion about environmental impacts and what we expected of the plan as a whole in this building. So what do we need to do again here? And I know, I think partly you don't think that the commission, I think you think responsibilities run beyond that. But also, can I ask you, do you think there were things that were kind of new where the plan, the phase 2, the stage 2 application was different, or new events that occurred that meant the commission really needed to think because of new developments in some way about the environment? Was there something that you think was kind of new or more detailed about the environment that you already knew was happening?
Well, 2 things, Your Honor. First of all, in the second stage, we're now seeing a lot more details of the plan. Finally, the site plan of the building of things. One of the things that was put on the record below by as a contested issue is the green roof. It's like, where is the green roof? I thought we were moving into the 21st century with thoughts of environmental protection and how it would keep from the runoff. I mean, here we don't know how parcel 2 meets or fulfills the benefits touted in the first stage. So if the benefits touted in the first stage to give a green light to the overall project, we would like to see now in the second stage how those benefits are actually implemented.
Well, I think that, again, I'm not sure. Did the stage 1 application discuss and the commission's ultimate ruling in the stage 1 case say something specific about green roofs as it might relate to the building on parcel 2?
No, and that's part of the problem. It references overall, like there'll be this many square feet of green roof in the overall project. So now that we're getting down, I mean, for parcel 1, they did some of that. For some of the consolidated portions of the first stage, they looked at the green roof. They looked at other aspects of it that met the environmental benefits. But for parcel 2, now that we're getting it, I mean, parcel 2 hasn't been done in a consolidated way. We're getting down to the details now. We're asking the commission below, hey, how does this parcel actually implement the benefits that are touted in stage 1? And how do they implement the mitigations of the impacts that are stated in stage 1? In fact, this commission, in this case, for stage 2, says at point 59 in their findings on page 15 of the order, the application has been evaluated by relevant agencies and found to have no unacceptable adverse impacts. Now, we know from the first stage there will be adverse impact. The order that this court, vacated in the first stage, during those under the remand, they actually had hearings and they further discussed some of the mitigations and things of the impacts. Now the question is, how are those mitigations implemented here at parcel 2 specifically, for the overall allowance of the overall project? We have to see how it's implemented. We're not seeing that. In fact, they just blow it off. The commission blows it off, says, look, there's not going to be any impacts. So we disagree. A 230 unit building, 7 stories high, where there's nothing right now except for an open field and some beautiful underground water cisterns. There is going to be impacts. We want to see how the trees are used to mitigate noise, right? We heard, oh, they're going to plant trees and things in the first order to mitigate noise. Well, how does that actually appear on parcel 2? Now, what we do see the commission do, though, like I said, is get down into details about the loading docks, get down into details about the color of the windowsills and the materials, okay? But we were
Mr.
asking
Otten.
for some more details. Yeah.
And I think we have your
Yes.
argument, and we're going to hear from the zoning commission now.
Thank you very much.
Good morning. May it please the court. Philip Evans on behalf of the intervener, Jair Lynch Development Partners. The zoning commission has submitted a statement in lieu of brief, so I'll be arguing on behalf of the intervener.
Mr. Otten, can you mute your mic? We're hearing a little bit of feedback right now.
Yes.
I think.
My apologies, Mr. Evans.
Not a problem. I think from the earlier statements from the court, you have crystallized the issue, and the issue is this. Do they get a second bite at the apple on the issues that the commission thoroughly addressed in resolution of the consolidated and stage 1 proceedings? And we think the case law and precedent is clear they do not. I pointed out the decisions in Carr and Harnett, and specifically the Randolph case. It's exactly the same template we have here. Impacts were addressed in the stage 1 and consolidated proceeding and resolved and not appealed or resolved by the appeal. Here at stage 2, which is a much more limited proceeding, looking at certain design elements of the building and certain traffic elements unique to this building on parcel 2, you cannot raise again the second bite of the apple to challenge those in the stage 2 proceeding.
Mr. Evans, but what about Mr. Otten's point? My understanding is stage 1 is the overall scheme, right? It's the big picture. And then you have the second stage of the PUD, where it's split up precisely for the reason that you want to be able to drill down into the details of particular parcels of the project, right? And what I hear him saying is, look, at this second stage, you're doing this much more detailed analysis of loading docks, but we're not seeing any more detail about environmental protections. So fine, you said at stage 1, this building was going to be LEED certified gold, but what does that mean for parcel 2? What about parcel 2 will fulfill that LEED certified gold qualification?
Well, what's critical?
Do you disagree with that's what's going on factually? And if not, then what's wrong with that argument legally?
What's critical here is to understand what happened at stage 1 and the issues that were identified and the benefits proffered on the environmental issues. So when you talked about the project itself as a whole, all 7 parcels on this are LEED gold. That's a project-specific environmental concern. The building in parcel 2 is LEED silver. That's unique to that building. But the issues that Mr. Otten has raised today in terms of green roof, bioretention facilities, sustainability, the trees on the Olmsted Walk, those are all covered in the stage 1 proposal and are documented. And most of them, to be perfectly honest, occur on parcels other than parcel 2. There's no obligation on each specific parcel to balance each element approved in the stage 1. That's how you do a massive project, that you do different areas of the project to accommodate the overall environmental goal. The environmental issues to look at on this project are what impact does the stage 2 proposal contain? Now, using common sense, the stage 2 proposal reduced the building in height by 27 feet. It cut the number of units by 50. It cut the number of parking places by 90. The only significant design contention was whether a bridge between the two buildings on parcel 2 was clear or opaque. Those are the issues the commission resolved. They did not blow away the environmental issues. They, in fact, reminded the applicant of their obligations on parcel 2 to include lead silver in the application. And I think the better way to look at this is look at the traffic analysis. The traffic analysis goes to the project as a whole. That was the concern, that the massive project known as McMillan, all 24 acres of development.
But before we go to the traffic analysis, I just want to make sure I understand. So your point is, look, parcel 2, the building is LEED certified silver. And if you work that into the overall plan, a LEED silver building plus the components of the other second stage PUDs for the other parcels will add up to a LEED certified gold in the end.
For project, yes.
So you don't have to worry about it. We're meeting our mark of LEED certified silver for this parcel, for this building. And we're going to do the other things that are not relevant to this second stage PUD for the other parcels, and we'll get to LEED certified gold. So there's really not anything else to talk about. Is that
That's
the bottom
correct, Your
line?
Honor, because it's unique to what you're doing on parcel 2, which is a smaller parcel with a multifamily.
Just
building.
one thing that sort of bugs me. I mean, at what point, like if there were slippage in other parts of the second stage PUDs, at what point would somebody be able to say, well, wait a second, there's a little slippage here and there's a little slippage here, so you're actually not going to get to LEED certified gold because you didn't quite do what you needed to do here or there or in the other place. Does that make any sense?
Makes any sense, and let me explain to you how it's going to work. To get certificates of occupancy for all of the parcels on the McMillan project, the applicant, and applicants in this case, because there are multiple applicants, must demonstrate full compliance with either a consolidated PD order or a stage 1 and a stage 2.
A certificate of occupancy, I mean, that's way downstream. I mean, everything is built at that point when you're trying to get people to move in.
That's how you hold the developer to the promises it made in a zoning review, which is.
Well, no, Mr. Evans, couldn't the developer be held at an earlier stage? If, let's say you get to, I don't know, parcel, the fifth of the second stage approvals, and an objector comes in and says, there was a commitment to get this project as a whole to LEED gold. And then there were very specific, determinations made at stage 1 about particular parcels, like parcel 2 was going to be LEED silver, the building was. But some things have changed. And there was a change to the plan for parcel 3 that means that building which was going to be gold, got approved, or someone's trying to get it approved as silver. An objector could come in and say at the stage 2 process too, couldn't the objector, and say, this isn't going the way it was supposed to, and commission, you need to stop it now, because if you approve this stage, for parcel 5, if you approve this the way the intervener wants it to be approved, you'll end up making it impossible for the project as a whole to comply with what stage 1 promised it would as a whole. Couldn't that be raised in the context of a stage 2 application with respect to a particular parcel?
The stage 1 approval, which covers all 7 parcels, flows through to every stage 2 proceeding. So if there is some objection, even though I really can't fathom how it would work, the commission always has authority to look at compliance with its original orders.
So is that a yes to my question? I just want to make sure I understand. That's a yes. Okay.
But I
Can I
think
ask you, I get your overall thematic point that at least a number of the objections that the objectors were raising at stage 2 arguably are duplicative of or overlap with or adequately addressed at stage 1. So I have that general point. There are some specific things that they raised that do seem to be newly available to them in connection with the stage 2 application. For example, the point is made in the brief in this court that both of the stage 1 orders required that a part of the stage 2 application would be an update as to the implementation of the Transit Implementation Plan, or TIP. And the point is made that if you look at the stage 2 application, there is no such thing. You agree that that point is wasn't addressed at stage one and isn't something that's already been resolved. It's something for us to address in this case without regard to the points you make about collateral estoppel or res judicata or related ideas. Is that right?
I would agree that there was a traffic requirement at stage 2 as particular to parcel 2. But what the petitioners omit is the discussion of that very evidence that was put before the commission in the traffic study plan, which we had to attach in our supplemental appendix. So the very unique traffic issues as it relates to parcel 2, the loading, the parking
Well,
configuration.
just ask procedurally, because there are a lot of acronyms being thrown around there and references to the supplemental appendix. Is it accurate or not accurate that the stage 2 application did not contain anything that was labeled or that in substance was an update as to the implementation of the traffic implementation plan?
It's inaccurate because the traffic demand study provided as Exhibit 23 in the record, it addresses
Exhibit
exactly
23 to what now? Exhibit 23 to what? To the
the-
stage
to
2 application?
the stage 2 application.
Okay,
Yes.
I'm sorry.
And
That's
the
the
order-
traffic. To describe what that was, that's the traffic. There's the TDM and the TIP, and there are a lot of acronyms. So I want to make sure exactly what you're referring to.
The study that was produced as Exhibit 23 in the record below, the stage 2 proceeding, and which was relied upon in the order, deals principally with a transportation demand management, which is limited to parcel 2. But there are discussions within there about how it's part of the overall transit implementation plan and transportation protection plan.
And what is it? And what information does that document contain about what the intervener is doing with respect to transit implementation in particular? What's the update about the implementation of the pre-existing transit implementation plan in the document you're referring to?
I think it references does not provide specific documentation as to that because it's part of the overall.
Well, leave aside
acronyms.
documentation. Does it provide specific assertions or statements about it?
It discusses within the report itself how it impacts the overall transit issues that relates to the McMillan site. And that's
Can you be more specific about what it says about any effects on topics that were covered by the transit implementation plan?
I have to just ask you to refer to the document itself for that sort of clarity. It's a level of granular detail that I'm just not prepared to talk about today.
And let me ask you also just on the procedural set of things that are open to us. You agree also that the argument that the building, as it has been more specifically designed in connection with the stage 2 application, the argument that it treats affordable housing in the location of those units in a way that's inconsistent with the stage 1 application and the requirements, really the order relating to the stage 1 application. You agree that argument is properly in front of us to decide without regard to the concerns you raise about other arguments being and have already done the second bite of the apple. That's a first bite at that apple, you agree, is that right?
Well, actually, no, because that issue was not raised before the commission. And this court's precedent.
I understood they may be trying to bite that apple too late, but I just want to make sure it's not a second bite at the apple.
I don't see it as a second bite of the apple, but also don't see that the affordable housing changed. As evidenced in the stage 1 plans, and then as you move to the stage 2 plans, the location of the affordable, of 25 of the affordable units is the same. The change is there were 2 additional units added in stage 2 at the request of the zoning commission, the 2 50% AMI units. So those were added and the commission relied upon that in fulfilling the affordable housing requirement. Again, it's an affordable housing requirement as to parcel 2, but you can't look at it outside of the overall affordable housing commitment for the consolidated in stage 1 McMillan process, because they do go hand in hand.
And I guess just to ask you one question about the environment, at least for my part, it's a part of Mr. Otten's argument here today, I think, that it was incumbent on the commission if it was going to perform what the regs refer to as a detailed site plan review, which is part of what second stage entails. It was incumbent on the commission to be more detailed about environment. There is the sort of general assurance that the prior approval for this building is LED silver, but now we're getting into greater details. Where are the trees going to be located? How many blowers are going to be on the roof? Are they going to make noise? Sort of the level of detail that was shown about loading docks and the like. and that the commission really was painted with too broad a brush, to pick a different metaphor, in just sort of saying, well, we really, as specific as we're going to get about environment in this building is to require it to be LLD silver. We're not going to micromanage the rest of it. We already approved LED silver in the first go round. Why is Mr. Otten wrong, if you think he is, that the commission really needed to descend more specifically into some of the concerns that he's mentioning today?
Well, I think that those concerns were addressed in the stage 1 proceeding. The lead silver is a component that's designed the physical structure of the building itself. But a question of, say, trees have been raised, that's defined in the stage 1 order. It shows the location of trees as part of the landscaping plan. The air handling units were identified early on in the stage 1. The fact that
and just to be clear, you think the stage 1? Do you think the stage 1 order required that the trees be placed and that the air handlers be placed as reflected, or is it your view that the commission at least said in the stage 1 proceedings, don't worry, we're happy with where the trees are around parcel 2, and we're happy with the number of blowers that are depicted on parcel 2, the parcel 2 building?
Two different elements. The trees were identified in the landscaping plan. The landscaping plan was approved in stage 1. The building 6 also had a plan approved for the building, but that was modified in stage 2. But those plans, which are attached and referenced in the order, those are the plans that the applicant must build from. They can't willy-nilly decide to put something or move something else. So the commission did approve them. Whether they had a specific finding as to the air handling units, which are a requirement on any multifamily build these days, that's the term of art for how you handle heating and cooling. They did not address those in specificity as to environmental, because they are part of the building requirement.
And is it an aspect of your point that the information at stage 1 was sufficiently granular about all that if an objector wanted to raise concerns about that, they were available to be raised at stage 1?
That's correct, Your Honor. I mean, air handling units were identified in stage 1 and stage 2. They're not unique to the stage 2 design. What the commission has to look to, what are those elements raised in the stage 2 design? And we've gone through them. They were just a reduction in the building, reduction in the number of parking places. The commission spent great time talking about the views from the bridge that connect the two buildings. Can
I ask you a question? Sorry to interrupt, but let me ask you, I know you're over your time and I don't want to keep this going on too long, but I did have one question about the record. Do you know the answer to the question that I asked Mr. Otten about whether someone raised to the commission the concern that the application, the second stage application, was missing the required update on the implementation of the transit implementation plan?
We believe, that information was contained in Exhibit 23 as submitted.
That's not my question. Just my question is about whether the claim. I know you don't agree with the claim that something was missing, but my question is, was that argument made to the commission? Did an objector say to the commission, "Hey, wait a minute! Don't approve the second stage application. It's missing its update as to the transit implementation plan, as the implementation of the transit implementation plan"?
I do not believe there was specific objection made using the acronyms you now have adopted.
Well, I'm not adopting any acronyms. Far be it from me to make new ones.
That's well beyond our jurisdiction.
Yeah, I'm just repeating the ones that the commission and the parties use.
I think a better way to answer your question here is that the brief goes into far more detail as to the objections that was ever raised below before the commission.
Right, counsel. Unless I have here any more questions from my colleagues, we're going to go back to Mr. Otten for a brief rebuttal. Mr. Otten, you're still muted.
Can you hear me now?
Yes.
Thank you, Your Honors, for this time and opportunity to argue this case before you. In the District of Columbia, when we hear the word planning, we truly want to see planning done. In this second stage review, when we're supposed to get down to the specifics, we see an order that says, your application has been evaluated, there will be no unacceptable adverse impacts. We do not know, as of today, how the trees and the landscaping is going to mitigate noise from this building to the surrounding community. We do not know to this day how the fire department and police department, which is already stretched thin, is going to be able to access and save potentially people out of this building, and also the historic assets at the site, given the traffic implosion that is expected there. We want to see planning involve ensuring that during the second stage, the benefits touted in the first stage are actually being implemented through the parcels that are a component of the first stage. So if they're touting the benefits of LEED Silver, that's one issue. That's just kind of, some of the emissions and things that are associated with the site. There's noise issues. There's the blowers on the top. We talked about green roofs. How is Parcel 2 implementing the benefits touted in the first stage? Also, how are the mitigations touted in the first stage being implemented in Parcel 2 and in this second stage review? We don't want to see a commission just say, oh, there's no adverse impacts and just brush this aside, yet simultaneously acknowledge there are going to be impacts enough with 3/4 street and the loading, and look at that stuff, but not look at other things. We think that's unfair, and we hope you'd vacate this order so we can actually have some planning done in this city. Thank you.
Thank you very much, Mr. Otten. Thank you, Mr. Evans. We appreciate your time today. And this case will be submitted. Good morning. We have our third and final case on the calendar this morning, 19 CV 565, Allison Sizer et al. Versus Fabiola K. Lopez Velasquez et al. Counsel, Mr. Michaelman, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
Yes.
And then Ms.
Yes, Your
Lori-
Honor.
I'm sorry.
I
If appellee's counsel could mute her mic.
yes, Your Honor. I think that was my fault. I still had the YouTube up. If you were hearing some feedback,
I was, but it's just easier if the party who is not speaking mutes just in case.
Sure. Very good. Yes, my name is Scott Michaelman for the tenants. I'd like to reserve 3 minutes for rebuttal, please.
All right. Thank you very much. When you're ready, you may begin.
May it please the court, I'll address the mitigation and consumer protection issues in that order. With regard to mitigation, this is a textbook violation of the duty to mitigate. The landlord sued the tenants after rejecting a make-whole arrangement with concededly suitable tenants in which they were promised deficiency payments from the outgoing tenants in advance. Their own management company recommended the replacement tenants twice, and landlords conceded at trial that they were willing to rent to these specific tenants. In sum, it could not have been easier for the landlords to mitigate their damages through this deal, but they held out for a better deal.
Sorry to interrupt, but just to jump right in to an issue that I see, it appears that the landlord may have had a mistaken understanding of the law. That she seems to think that if she took 2 streams of income, the $2,000 up front from you, and then $3,100 from the substitute tenants, that somehow she was reducing the value of the apartment, and that she would not be able to relet it for more. That seems incorrect to me. It seems like she could have written a lease that says the value of this apartment is $3,300 a month, and we're just getting 2 income streams here. And, you replacement tenants are just satisfying this 10-month tenancy. And I reserve the right to rent this at market rate after this 10 months. But she seemed to think that she could not do that. And I'm wondering whether, if mitigation is sort of what's reasonable under the circumstances, does that reasonableness extend to mistakes of law?
So I think your premise, Judge Easterly, is absolutely correct. I think she was mistaken. And whether or not that mistake was an innocent one, that doesn't make it reasonable. In fact, I think that demonstrates why it's unreasonable. Mitigation is not, reasonableness in the context of mitigation is not a subjective analysis, it's an objective analysis. And so it is not reasonable for the landlord to do something based on a mistaken belief that this was not a make whole arrangement. And so, and I think that would get the court into dangerous territory in terms of plumbing the depths of what landlords subjectively believed versus what their rights were and what their responsibilities were under the law. And I think that's why you see a broad consensus of cases, as we've cited in our briefs, considering very similar circumstances and saying, no, you've got to entertain the replacement tenants. You've got to entertain them if there's going to be, if they're going to pay a little less and take deficiency payments. You can't arbitrarily put on other requirements about what their business is or what their occupation may be. But you've got to, as the restatement says, which this court has adopted and looked to in the past, you've got to avoid damages that could be avoided, quote, without undue risk, burden, or humiliation.
So what
No risk or burden here. This was entirely a make whole arrangement. In fact, they would have gotten the deficiency payments up front.
What do you say to the trial court's view that, look, this wasn't a rejection of the replacement tenants? It was a counteroffer. All things being equal, landlord would prefer the lease, say $3,300. Maybe that has some downstream effect of how much she can relet the property for at the end of the lease term. So she'd rather have it be $3,300. Seems like a reasonable counteroffer to say, look, that extra $2,000, you guys can work that out amongst yourselves, but I want my $3,300. That's my position. And then the prospective tenants walk. And that seemed to be what the trial court said, which is reasonable enough to counteroffer. And at the point of the counteroffer, the replacement tenants walk away. What's wrong with that view?
Well, it's not that they weren't allowed to counteroffer, but the question is who bears the risk when they decide to counteroffer. And the duty of mitigation says that it's the landlords at that point who bear the risk. The landlords have the responsibility to mitigate where they're not undertaking undue burden, risk, or humiliation. Now, it's fine for them to counter, and maybe they can counter and the tenants walk and they...
Counsel, can I ask you, do you really mean what you just said so as broadly as you said it, or is it a premise of your answer that this was make whole mitigation? I mean, imagine that what had happened was that there was a lease for $3,300 and one of the party, the tenant was going to breach it and offered to a substitute tenant at $3,100 and didn't offer to supplement the difference. And the landlord responded by saying, well, no, I don't think that doesn't make me whole, and I'm going to try to rent it out for the full amount. If the landlord counteroffers in that way, and that's a reasonable judgment, but as it works out, the landlord ends up not being able to rent it for $3,100, more than $3,100, but it lays vacant for a couple months. Are you saying the landlord can't recover and that the landlord bears the burden of reasonably rejecting some form of mitigation that is not make whole mitigation?
I see. No, I think that's an important distinction, Your Honor. And I think that goes to the question of, as the restatement says, undue risk. And so in that circumstance, it is a premise of my answer that this was make whole relief. And if in that circumstance, it would be, I think, a question that would be much more susceptible to a factual determination. Was it risky in that moment to expect that the landlord would just take the 31 and hope she could recover the rest from the tenants later? Here, though, the tenants had said, here you go, we'll give you the money. And so under those circumstances, there was nothing more for the landlords to get. There was nothing risky about rejecting the offer. And I think the difficulty with following the Superior Court's reasoning on this is that there might be sort of no end to the tries a landlord could make, even in the face of make whole relief. Oh, well, we'll try to get more. We'll try to push this. We'll try to push that, and then the replacement tenants walk. And under the Superior Court's view, the tenants are left holding the bag, not the landlord who tried to push. And I think it's important to recognize that the DC Council adopted the duty of mitigation to level the playing field here between landlords and tenants, to avoid what courts in other jurisdictions have described, particularly the Vermont decision in O'Brien we cited, as making the duty to mitigate essentially optional and giving the landlords all the power here. At some point, there has to be a place beyond which they cannot go. And if this circumstance where it was make whole everything they could have possibly wanted, short of the actual same lease.
Well, the trial court here, the magistrate judge, to be more specific, found or concluded or explained, I don't want to prejudge, I guess, whether it's a factual finding or not, but made the statement that it didn't believe this was make whole mitigation. And this is on page 140 of the transcript of that hearing, that I think the 8/9/18 hearing, where the magistrate judge says, I think based on the testimony of the expert, based on common sense knowledge of housing markets and rental markets, the amount that a unit can pull depends on a number of factors. And it's not unreasonable to be concerned that the monthly rent amount of the lease for a period of time will impact what the next lease can be. First of all, do you have a sense of what expert testimony the trial court was focused on? I mean, I guess there's the statement of the expert that rental amounts depend on a lot of factors. Is that what you understand that reference to be too?
Yes, Your Honor. I think there are a number of problems with that statement. First of all, it's premised on an error of law that substitutes are not acceptable or need not be considered in mitigation, that it had to be make whole relief or they were free to walk away from it. That's not what any of the cases say. That's not what the restatement says. There's no authority for that anywhere that any party has cited. That's the first problem. The second problem is, as you say, she relied on this expert testimony, but all the expert said is there are many factors. It was the judge's own hypothesis, which she put a question to the expert about, and then later, I guess, concluded or found or decided for herself that there was some problem with this 3,100 because the landlords couldn't raise the rent. Now that's not, there's no testimony supporting that. And further, I
mean, there's testimony supporting the view that the landlord thought that.
The landlord thought that. That's true. But again, I think it goes back to Judge Easterly's question that the duty to mitigate and the reasonableness need to be looked at objectively, because otherwise it just depends on whatever the landlord thinks. And
well, even in areas where the inquiry is objective, now I'm getting very abstract here, but even in areas where the inquiry is objective, there is the concept of reasonable mistakes of law that can, it can occur in Fourth Amendment settings and qualified immunity settings and the like. So it's not invariably true that it's irrelevant if someone's making a mistake of law to whether it's impossible for a mistake of law to be reasonable. There are areas of law where we take the view that mistakes of law can be reasonable. And so it's an interesting legal question, I guess. Are you aware of legal authority on the question of whether if a party rejects mitigation in a mistaken legal view, that the mitigation wouldn't have been adequate?
I'm not aware
that it's irrelevant to the reasonableness of it, that there's no possibility it could be reasonable if it rested critically on a mistake of law.
I'm not aware of authority on that point, Your Honor, but I will say, Judge McLeese, that if you read all of the authorities in all of the briefs that are cited, I don't think a single one suggests that the beliefs of the landlord that rejected mitigation required a different result or could have saved them from.
Well, you would agree, wouldn't you? I mean, implicit in the idea of reasonableness is that sometimes you could be wrong. And so if a landlord, let's say that the landlord here had concluded that the substitute tenants were not creditworthy. And the landlord believed that to be true. And that was a reasonable belief because that's what the landlord's management company had said to the landlord. But in fact, the management company was wrong and the substitute tenants were creditworthy. So the landlord denied what would have been make-whole litigation, mitigation because of a mistake of fact. Would you say, just irrelevant, who cares what the landlord may have incorrectly but reasonably believed, whether on fact or law? Or do you draw a distinction between law and fact, or what's your view of that hypothetical?
Well, I think if the landlord had reasonably believed that, then it would be a tougher case, and maybe that's where where the reasonableness inquiry comes into play in terms of it was reasonable to consider that risky. But at some point there has to be a limit. The facts of this case could not have been clearer. The landlords themselves did not believe that. They, when asked, and this is on page 70 of the appendix at the transcript 48, when asked whether they would have rented to these particular people, Chavez and Moore, the replacements, Ms. Lopez Velasquez, the landlord, answered, "Of course." And in fact, they tried to rent to them themselves, just at a higher rate. So I think this court can leave some of those more esoteric questions for another day.
So putting aside the
Needs
question
facts.
of whether or not the landlord had a reasonable belief that it would be to her detriment to rent this out for $3,100, is part of your argument, I'm not sure that it is, and I'm just curious if you've made it at any point, either on appeal or below, that if that was her view, the reasonable thing to do would have been to go back to you and say, you're welcome to make up the $2,000 so long as the lease says $3,300. But I'm not going to let them sign a $3,100 lease because I think it affects my ability to rent it out more later. Did you make that kind of, they had an unreasonable reaction to the prospective tenant's offer? Is that argument floating around here or not? I mean, I saw it in your testimony a little bit.
Right. I think that would have, first of all, as a matter of fact, that would have solved the problem, right? We would have said, we don't care if the money goes through Chavez and Moore, we give it to you directly. We just want out of this and to make you whole and to do whatever we can to get out of this. I suppose, that certainly would have been a more reasonable response. But at some point when you're given all that you're entitled to under the law and you won't take yes for an answer, there comes a point. The facts of this case are extreme. If this case does not violate the duty to mitigate, then I'm not sure what does. This would contradict all of the case law. This contradicts the standard in the restatement. It would undercut the duty to mitigate by making it essentially optional, where the landlords can say, you know what, we can imagine a better deal. Why don't you give us a little more money? Why don't you have a better
Can I just ask you about that point, Mr. Michelman, because I do think that the way I see the testimony from the landlord is what she is saying is, look, I thought that I had to get all the money from one income stream. Otherwise, it was going to somehow reduce the value of this tenancy. She's not saying that she wanted more than the $3,300, right?
Right.
And you were saying, look, you're going to get $3,300. We're going to give you $2,000 up front, and you're going to get $3,100 a month from the tenants. And she's saying, no, I can't take that. I have to get it all from the tenants because otherwise it undervalues this lease, right? So, and I don't see that So to the extent that this is a question of whether or not there was a failure to mitigate because the landlord wanted more than 3,300, I don't think that those are the facts here.
I see. No, I take your point, Your Honor. Yes, they wanted 3,300 from these tenants, but there are two, I think, clear
And I
responses
just want
to
to
your.
clarify too, that the magistrate judge also didn't think that the landlord was seeking more than 3,300, right? It's just a question of where does the 3,300 come from, and does that affect the market value of this tenancy?
Right.
Those are the operative facts here.
I think that's right, Your Honor. But
Okay.
I think there are two clear responses to that, and difficulties with the landlords and the trial court's view. First of all, this is a businesswoman, and she was in business renting an apartment, and she had a management company to advise her. It's not really. I mean, maybe she made a mistake of law. It wasn't a reasonable mistake of law, I don't think, and it wasn't one that the law should permit landlords who are in business doing this to make. And further, I think, when we go back to the restatement, which this court has cited, it says over and over in comment B, in comment C, in comment E, which we've cited in our briefs, that substitute transactions are part of the duty to mitigate. You don't get to say, I want exactly the same deal and or not, or no deal. You can say you must be willing to take a substitute in mitigation and look to the breaching party for compensation. And here, that's exactly what was proposed. That's what happened in our cases. And we cited two cases, Scheinfeld and Vaughter, that said specifically that it wasn't good enough for landlords to say, well, the replacements weren't willing to sign the same lease. They would have given us some other amount. So goodbye. No, the court said, no, you have to accept the substitute and deficiency payments. And that's what they were supposed to do here. And I think one more point on that, Your Honor, is
Okay. And then I quickly want to move you to the CPPA.
to the CPPA.
Yeah.
Right. No, just one more quick point on that. And I recognize we're taking a lot of time. It's telling what they asked for in their own complaint. They asked for damages through the end of the lease term. They did not ask for damages beyond the end of the lease term, because the lease term only promised them a tenant through May 31st, 2018. And so I think that goes to show the sort of speculative nature of this idea that somehow they had changed the value of their apartment. So I just don't think that's a reasonable mistake. It's not one that the law allows. It's not one that landlords should be allowed to make.
Right.
So if there are no other questions on that, CPPA?
Yes, please.
Okay. So this is actually a fairly simple argument. The landlord violated the CPPA in two ways. First, the illegal lease provision on the attorney's fees, and second, the made-up lease break fee, which is actually doubly misleading. First, they suggested there was a lease break fee, which was not in the contract, and second, they suggested that not paying the lease break fee would undermine the legal duty to mitigate, which is also incorrect. The question is, does the new clarifying act apply to enable the tenants to have a cause of action? And the answer is found in the Landgraf criteria adopted by this court, which are ultimately about fair notice. This is a quote from Landgraf: reasonable reliance and settled expectations. And there are only really 2 points of law here. One, it was illegal when they did it. Two, it was remediable when they did it. And so they weren't entitled to rely on their ability to break the law and hope the DC Attorney General was too busy to sue them. That is, that is the nature of the reliance interest here. It's not one this court should recognize, because this
Can I ask you about the second of your 2 points,
Yes.
which has to do with the remedial nature of the statute? It touches on that aspect of things.
Yes.
And you do rely on cases of ours that have language in them for the idea that one kind of presumptively applies remedial statutes retroactively. But I'm a little puzzled about that, and I'm wondering if you can shed light on it. we do have some cases which have said that, including some older cases, but also some more recent ones. Some of them rely on the Supreme Court's decision in Landgraf, which we've kind of, I think you might agree, have sort of adopted as our retroactivity framework. But in Landgraf, when Landgraf does refer to that idea, it does at least in two places in the majority opinion that I can see. One of them is to say, you know, there are lots of conflicting things that courts have said about retroactivity, and here are two of them, you know, here are several of them, and that's one of them, which isn't really Landgraf endorsing that idea anymore. It's more saying, look, that's one of the things that people have said, now we're going to try to clarify. And that's, I think, maybe in note 16. And then in note 37, the Landgraf court goes on more and says, we have said sometimes that remedial statutes generally apply, presumptively apply to pending cases, but you know, that can be a problem, and it's not always true. And then there's a further discussion of it. So I find it pretty unclear under the Supreme Court's case law and ours, to the extent it is following Landgraf, whether it's right to say that one presumptively applies remedial statutes retroactively. So I wonder if do you have any further thoughts on how you square the idea that presumption survives Landgraf with the language in Landgraf I was just discussing?
Yes, Judge McLeese. I think here's how I'd put it. This court and the Supreme Court have continued to refer to this idea that there's a presumption that remedial statutes apply in a backward-looking fashion, but that presumption can be overcome. And it
I just make sure when you say continued, you say the Supreme Court after Landgraf. I mean, referring to a doctrine doesn't necessarily mean you're endorsing it. If the way you refer to it in Landgraf is to say, that's a thing we've said, it contradicts other things we've said, and here's our new test. And by the way, here's some further explanation about why that earlier thing we said isn't really right. And that's certainly a reference to it, but I'm not sure it's a reference to it that means we should be carrying it forward. Do you mean after?
This court has carried it.
You mean after Landgraf? First of all, focusing on the Supreme Court, you think the Supreme Court has treated that as an operative presumption, that there's a presumption that remedial statutes apply retroactively?
No, I can't cite a case for the Supreme Court on that, but this court certainly has.
Well,
and
when we have, do you know whether we've discussed the limitations in Landgraf that I was just describing?
I believe so. I would have to go back specifically to see how those interacted, but we have cited those cases in our brief. And many of them are more recent. They are.
Well, Holsager is one that you cite for sure, and it quotes, just a passage from Landgraf that doesn't really fully lay out all of the complexity there. So I don't know that it gets into the difficulties. Now, so that's at least one of the cases you rely on, if I recall correctly.
Yes. So the ones that I would. So this court has said a number of times in the past 15 years that there is this presumption. They said it in Holsager, they said it in Lasik, they said it you said it in Lasik, in Omedehu, and in Webb. All of those are cited in our brief. Now, I agree it is not the end of the story. It's absolutely not the end of the story. That's why I think, and a critical part of our argument is then you look at the Landgraf criteria. So you presume you apply it, but then you look at the criteria, and the criteria say, did it impair the rights? Did it increase the liability? Did it impose new duties? And at the heart of those is, quote, fair notice, reasonable reliance, and settled expectations. And that's where the critical fact here is just as illegal now as then, just as remediable now as then, by the same remedies, just by a different.
Would you agree that in some of both the Supreme Court retroactivity cases and in ours, we've said as part of the test about whether a statute is retroactive in a way that triggers a presumption against its retroactive application, that the issue is whether it attaches new legal consequences to earlier acts? Is that one of the phrases that we use?
Yes.
And the Supreme Court uses?
Yes.
If we focus on that phrase for a moment, don't you think that permitting a new entity to bring suit, essentially creating a new cause of action for a new entity, it creates a new legal consequence? I get your point. I mean, I get your points about it was already illegal, and I get your point as an original matter about why are there really strong reliance interests. So I fully get all those points, but just in terms of what our case law has been and how doctrine works, doesn't it seem like that is attaching new legal consequences to acts after they were engaged in?
No, Judge McLeese, I don't think so, because when we're talking about consequences, I think we're talking about what are the remedial consequences. Can you be liable for statutory damages? Yes. Can you be liable for attorney's fees in that suit? Yes. Can you be liable for costs? Yes. The Attorney General had that authority at the time, and so there are no new consequences.
Let me ask you a question about how you understand the relationship between our retroactivity law and the Supreme Court retroactivity law. I think there may be some subsequent Supreme Court case law that sheds light on this question we're discussing about kind of previously unlawful conduct that you could have been sued for, but then new parties are made available. Assuming for a moment there is Supreme Court case law on that topic, do you think that we are obliged to follow it, that we should follow it, that we're free to chart our own path? What's your view kind of about the connection between our retroactivity jurisprudence and the Supreme Court's?
I think this court has adopted the Landgraf test, but I don't think all applications of federal statutory interpretation bind this court. And what I think you're referring to the Hughes case, and I'd point out that the reason that this court shouldn't adopt it is not only is this court free to chart its own course, but in fact there are two other states that have gone the other way on that same question. So there's kind of a division of authority, and in fact both and I'll give them to you now. Hess versus Chase Manhattan Bank, 220 Southwest 3rd 758 from the Missouri Supreme Court in 2007. Niles Freeman Equipment versus Joseph, 161 Cal App 4th 765 from 2008. These are two cases that.
Can I ask you a question though, just as a prep story? Am I misrecollecting, or am I right in believing that Hughes Aircraft is not a brief that's not a case that is discussed in your brief or in any of the briefs of the parties? Is that correct, or am I misrecollecting?
No, that's right. And you know, I think the law of other jurisdictions in this situation is mixed. We've got Hughes on one side, we've got Niles Freeman and Hess on the other side, and so you know, I mean, in Hess and Niles Freeman, they said, well, Hughes is very specific to the qui tam context, where there's this idea that qui tam relators are what the California Court of Appeals said. It said they're mercenary, and then it said in reasoning, I think is and that's at 787 of that of the citation I just gave you of 161 Cal App 4th. It also said the defendants can't have, quote, reasonably relied on, and a little ellipsis here, escaping consequences for fraud, unquote, based on, again, quote, the hope that the Attorney General would conclude that the case did not merit, unquote.
Yeah, I get that point as an original matter for sure. Let me just ask you one other question. I know
there's
belaboring this, but it's my impression that the federal courts of appeals have applied Hughes Aircraft pretty broadly to statutes other than to settings other than the qui tam statute, and have taken from it a somewhat broader lesson, which is if you're creating a new cause of action, you trigger the presumption against retroactivity, and therefore you need to look to clearly express legislative, express language or clearly express legislative purpose. Do you have a different view, or are you not conversant with what the federal court of appeals
I am not conversant, but I will say that I think I think to me it comes down to fairness and reliance, and so I think it is quite reasonable for defendants to be held to answer for their actions that were illegal when they were taken and remedial by the same context. I just think that's the fairer application of the Landgraf principles. And so to the extent courts of appeals, which I admit I haven't read, might go other ways, I think this court is free to disagree with them, and I think you should.
All right. Thank you, Mr. Michelman. We'll now hear from
Thank you, Your
Ms. Laurie, and we'll call you back for a little bit on rebuttal.
Yes, may it please the court, Vanessa Carpenter Laurie, I'm counsel for the appellees, the landlords. And with respect to the initial argument with regarding the mitigation, the magistrate judge specifically found that the actions taken by the landlords to mitigate their damages were reasonable. They attempted to start advertising the property immediately upon being notified by the tenants that they intended to breach the lease. The issue with respect to the prospective tenants that were presented by Mr. Michaelman and Ms. Sizer was a brief interaction. They did not propose to submit the lease term that Ms. Sizer and Mr. Michaelman were obligated under, which was $3,300 a month. And the tenants—
I don't understand that. Because what they said was, look, we're prepared to give you $2,000 up front, $200 a month for each of the months that we will not fulfill the lease term. And these tenants will pay you $3,100 a month, and $3,100 plus $200 is $3,300 a month. So what, I don't understand the argument that this was not of the same value.
Because as we indicated in our brief, once the tenants accepted that $3,100 a month lease agreement with the prospective new tenants, they were at $3,300 as a lease amount. And the expert that testified was actually the expert for Mr. Michaelman and Ms. Sizer, who said that that would downgrade the value of the lease and the marketability of the property.
Just give me a citation.
Where did she say that?
That's in the testimony. I can't
Can
quote
you
it
give me a
exactly.
page number where she said that?
Well, the judge referred to it, and I think that the court previously during the prior argument referenced it, that the magistrate judge referenced the fact that the expert had testified to that effect, and she used that.
I know the judge said it. I'm just trying to figure out where the expert said it, because I'm not quite sure that the expert understood that the judge accurately captured what the expert said. So setting aside that, if the judge just came up with that, what is the basis for that statement? Because it just seems like a simple math problem to me. 3,100 plus 200 equals 33. Why is that false?
That is not false, but that does not necessarily make my clients whole, simply because now they have a lease for $3,100.
No, they don't. They have a lease for $3,300 with 2 income streams.
But Your Honor, the question is, under DC law, those tenants would have been able to stay in the unit at the $3,100 lease. And the only way that my clients could get back to where they were at $3,300 after the Michaelman lease expired was to have a huge increase in rent.
Ms. Laura, you say that's true under District of Columbia law, and your opponent disagrees with you and cites some case law and then some trial record materials that indicate that it was undisputed that the unit at issue was not a rent-controlled issue. So what statute, is there a statute or a case of ours that you would point us to? Because I don't remember seeing one in your brief that supports the view that you're taking and that the landlord seemed to take, that there would have been legal consequences at the end of the lease if someone had conceptualized the substitute lease as $3,100 rather than $3,300, which itself is, as Judge Easterly's question suggested, an unclear question of how you conceptualize it. But what statute or case law would you point us to say that if you think of the substitute lease as $3,100, that would have legal consequences as after the date of the end of the substitute lease?
So, Your Honor, what I'm referring to is the fact that my clients would not have been able to terminate that lease except under certain circumstances under DC law.
Right, and what DC law, my question is, what DC statute are you referring to when you say that about DC law?
I believe I referred to it in the brief, Your Honor, and if I may. I refer to the cases, DC Code, Section 42-3505.01, subparagraph A, indicating that a tenant can't be evicted except under certain circumstances. And so the leases automatically go month to month after they expire. So if a
And can
lease,
I ask you, looking at that provision exactly, what it says is, except as provided in the section, no tenant shall be evicted from a rental unit, notwithstanding expiration of the agreement, as long as the tenant continues to pay the rent to which the housing provider is entitled for the rental unit. And I guess it seems to me, again, this is a confusing, it seems to me at least unclear, and assuming the applicability of this provision, whether the substitute tenants would have been in a position to say, no, the landlord was entitled only to $3,100 under the prior lease agreement, or not. It seems to me very unclear.
I don't think the landlords would have been obligated to stay with the $3,100 a month lease. They would have had the right to raise the rent. There's no question about that, because they were not under rent control. But there was already a representation by these prospective tenants that they did not want to be obligated to pay $3,300 a month. So,
I'll make sure I understand. If the landlord had said, assume that in the world where the substitute tenants had arrived and it started occupying under the lease, and if the landlord had decided, my plan, I would like to raise the rent, either I would like to make sure the substitute tenants going forward pay $3,300, or I'd like to raise the rent like I might have done for the prior tenants to $3,500. So the landlord plans ahead on that and says, okay, sends a notice to the substitute tenant 3 months ahead of time and says, here's the deal. The tenancy is about to end. It was for $3,100 or $3,300, depending on how you conceptualize it. But here's what we like to do going forward. And if you don't like that, then obviously your lease term is over and you need to leave. Are you saying that you're saying that the landlord could do that? I think, is that right? Because it's not rent controlled. That would be lawful for the landlord to say.
the landlord could send a notice saying that they wanted to increase the rent.
And demanding that the tenants leave if they don't agree to the increased rent.
If the tenants don't leave, and that was part of the issue, if the tenants opt not to pay the additional amount.
No, we'll get to that point in a minute. I just want to walk through it. It is correct, is it correct in your understanding of things that the landlord could have not only said 3 months ahead of time, look, this lease is going to end. You need to leave on the end of the lease unless you're willing to pay me $3,500. A, the landlord could say that, and B, the landlord would be acting legally and demanding all that. And if the landlord did all that, I guess this gets to C, the tenants would have been legally required to leave rather than remain. You think all that is true?
Well, Your Honor, theoretically that's true, but if the tenants did not leave, if they decided to stay, the landlord would have been obligated to go into landlord and tenant court to get them out, since there's no self-help.
And that's true without regard. That would have been true of the prior tenants if they decided to illegally overstay the term of the lease and had rejected the only offer under which they could lawfully occupy the premises thereafter. So I don't see how that distinguishes between the substitute performance and the original performance.
Well, the original performance was for a lease for $3,300 a month.
I understand that, but maybe is your further point that if the tenants illegally overstayed, if the substitute tenants illegally overstayed, and then an issue arose about what the measure of damages would be to the landlord because of their illegal overstaying in the hypothetical we're discussing, are you saying that the amount of damages in this case would have been $3,100 rather than $3,300?
The tenants have to agree to pay the additional amount. And if they don't agree to pay it and don't vacate the property, the only option for the landlord is to file a complaint for possession.
I got all of that. My only question is, I don't see none of that. I haven't yet seen how that changes the situation from the original performance, unless it's your view that when the landlord went to that remedy, if for some reason it had to, which it had no more reason to expect it would with the substitute tenants than it did to expect with the original tenants. But if it did, if the damages would be the same too, then I really am having a hard time understanding how in any practical or other sense, the substitute performance was inferior to the original performance.
No, I don't believe that the landlord would have had the right to try to seek $3,300 a month from the substitute tenants if they did not vacate and did not agree to pay the additional amount. But I think it's sort of.
And just to be clear, you say you don't believe that, but are you aware of, I mean, that doesn't make much sense to me as an original matter, why that would be true. Are you aware of cases or statutory provisions that would say that in a setting like that, in this case, the landlord would have been limited to a recovery of $3,100 a month of damages for an illegal overstay by the substitute tenants?
I believe that to be the case, Your Honor. The tenant is only obligated to pay what they've obligated to.
Well, no, the tenant, but if the tenant illegally stays beyond the lease term, then the tenant is obligated in damages to whatever damages the landlord suffered.
Well, it isn't the end of the lease term because the lease goes automatically month to month after the termination of.
That's not true. If the landlord says 3 months ahead of time, I'm giving you notice, this lease is over unless you pay me more money, then how does it automatically go month to month?
Because that's the law in DC. You can't evict.
What is your citation for that?
Your Honor, I'll go back to the original citation. You can only evict a tenant for the specified reasons in the statute, which was quoted.
Yeah, and reason B in the statute, 423505.01B is a housing provider may recover possession where the tenant is violating an obligation of the tenancy and fails to correct. And I mean, if one of the obligations, just leaving this, but obligation of the tenancy, one of the obligations of tenancy is to vacate the property once your tenancy ends. But just so your view of the law, just make sure your view of the law generally is.
Well,
if I sign, let me just finish my question. If I sign a lease with a landlord and it's for a 12-month lease and it's for $1,200 a month, and the landlord tells me ahead of time with notice under the lease, I'm not renewing this unless you pay me $1,500, and I illegally overstay, and the landlord sues me and tries to evict me. First, are you agree the landlord could evict me even if I pay $1,200 a month? It's not like I can get a life tenure at $1,200 a month for the to stay in the unit, right?
You don't get a life tenure. The landlord has the right to send a notice, 30 days notice of intent to raise the rent if they're not under rent control.
So they could evict me. And then if I get evicted, but it takes a while to get me evicted and I overstay for 3 months, your further view seems to be that the landlord can only get damages in the amount of $1,200, the illegally extended lease, rather than an amount that the landlord could prove, if it could, about what the landlord would have been able to do if I had acted lawfully and the landlord had been able to rent to a different tenant who would have paid the greater amount.
Well, landlord in tenant court is just a court of possession for, and in that event, if the landlord sent a lawful notice of increase in rent, the tenant failed to pay it, refused to pay it, and stayed in the unit, the landlord in tenant court is for possession only. It's for possession.
Yeah, my issue is really not about which part of the Superior Court I'd have to bring my lawsuit in, whether I might also have to bring a civil action to recover damages. But I'm just trying to figure out if you think in damages, if I'm an overstaying tenant, that a cap on the damages against me is the amount I agreed to pay for the expired lease, or whether a landlord in an appropriate action could establish the damages in a greater amount if the landlord could prove, well, if this person hadn't illegally overstayed, I would have rented it out for $1,500, and so my damages are $4,500, not $3,600.
Right. So the issue is when these prospective tenants were advised of what the bottom line rental amount was, they were the ones that withdrew. They withdrew from being considered, and even in the exhibits.
I'm sorry, they withdrew after they were told that the rent that was expected from them personally was $3,300, right? The landlord knew that the outgoing tenants were ready to pay $2,000 up front and had tenants who were ready to pay $3,100. And the landlord counter offered to the new tenants and said, no, I want you to pay $3,300. And that's when they walked away. So that's that's a rejection of the $3,100 plus $200 a month offer.
I
Do you
don't
disagree? Do you disagree with that?
No, I don't believe that they were told that they were expected to pay it. I think they were told that the lease was for $3,300 a month.
Well, what do you think that means if they're told? I mean, they're told by the outgoing tenants, hey, you can pay $3,100. And the outgoing tenants tell the landlord, hey, these guys are going to pay $3,100 and we're going to pay $200 a month. And the landlord goes back to the original tenants and says the lease is for $3,300 a month. It seems pretty clear that she's saying, I want $3,300 a month from you. Is there any other reasonable understanding of that statement?
No, Your Honor, but I think we need to get back also to the fact that the landlords were trying to find their own tenants.
That is fine if they want to find their own tenants. What we're talking about is the duty to mitigate and who bears the risk.
Well,
right. And so if they have a tenant who is given to them, who is willing to pay $3,100 and the outgoing tenants are saying, we're going to make up the difference, why don't they have to take that in order to mitigate, or they bear the cost if they cannot find their tenant who is going to pay $3,300 all themselves, or possibly more, possibly $35,000?
well, the bottom line is they tried to find a tenant. They were hampered because Mr. Michaelman took it upon himself to advertise their property for $3,100 a month, which obviously also reduced the potential value.
I'm sorry to interrupt, but I just don't see how that, I think we've got a narrow legal question in front of us as to why they don't have to accept the $3,100 plus $200 offer, or they lose the protection of having the outgoing tenants pay damages from breach of the lease.
I think that if the tenants had been willing to sign a lease for the $3,300, which is the lease that they had, which would have gone into month to month after the termination of the term, then they would have had to take it. I don't think they had to take it where they were ending up with a $3,100 a month lease that they would be stuck with, basically, unless these tenants agreed to pay the difference in the amount at the end of the lease term.
Okay, so I just want to understand why you think that's a meaningful difference. And I assume it has something to do with the end of the lease term. And one thing you might say is, well, if they rent it out to this couple for $3,100 a month, even though we're getting $200 extra, that's somehow going to affect how much we can rent it out for next. Another thing you might say, which you and Judge McPeace had a long colloquy about, is, well, the measure of damages, if they decide to overstay their welcome, is going to be different depending on what that lease number is. But I'm just not sure what your basis is for saying that. I'm also not quite sure what the trial court's basis is for saying that. So let me start with yours. You think that it wasn't good enough because what was going to happen at the end of the lease term that was going to put you in a worse position than you would have been with the original tenants?
Those tenants had already indicated they didn't want to pay $3,300. So my client,
but Mr. Mike, I mean, the original tenants were free to walk out too. I mean, they were free to say, we don't want to pay $3,300 after these 10 months.
well, but they would have been obligated under the lease for $3,300 a month. And if they decided they didn't want to pay it, then they would either move or we would be suing for possession, but it would be at $3,300 a month, not at $3,100 a month.
It sounds like you're making the measure of damages would be different if the lease by the replacement tenants would have been $3,100 and they decided to overstay their welcome. That is your theory of harm, which I don't think I ever saw articulated by the trial court, by the way. But am I articulating your theory of harm correctly?
That would have been a harm, and it was found by the trial court that it would have affected the later rental value of the property if it's rented then under a lease of $3,100 a month.
Yeah, I mean, but what we're talking about is way more complicated than that. I mean, we're now talking about measure of damages, whereas if the point is just if you rent it out to these people at $3,100 a month, despite a $200 makeup, that's going to what? Impact the general market for the apartment, which seems fairly implausible. And I'm not so sure there was any testimony contrary to the trial court statement. I'm not sure there was any testimony that would that view. They seem like two different theories, and it sounds like you're now saying a measure of damages theory, and the trial court was saying some more amorphous future value of the apartment theory that I'm not quite sure. Not quite sure it's the same basis that you're.
Well, you know, it was two things, and the court is reading the emails and the interaction, I think a little bit different than the sequence of events. But in any event, these tenants did walk away, and they decided not to proceed with signing the lease.
All right, do you have anything that you want to say on the CPPA claims?
Yes, just briefly. And the other thing I did want to say also briefly on the mitigation, all the cases that were cited specifically address the fact that these landlords turned down matching offers. They did not turn down otherwise. And there's in the Summer versus Crottle case, which is cited, the court specifically said that it was okay for the landlord to turn down an offer for a lease for less, and they were also allowed to advertise for a higher rent. And with respect to the CPPA claim, I think that the thing that comes up is that there was an addition in obligations. There was no right of private action before. In addition to that, there was added a potential for damages for a private party filing a claim of, I believe, $1,500, and that was not in the original CPPA. So I don't think it should be given retroactive application.
All right, thank you very much. And we'll hear just for a few minutes from Mr. Michelman. Oh, you're muted.
Yeah, now can you hear me?
Yes.
Okay, great. Thank you. So just a couple of points. I think the mitigation issue has been discussed exhaustively, but I just wanted to clarify two specific points. One, I think the measure of damages argument, as the court has articulated, is very speculative, as Judge Deal said, and I think that's and the fact that it's been sort of nowhere articulated by the magistrate judge or the superior court, and it's just this large sequence of events makes it an inappropriate basis to affirm. But I also wanted to the only other thing I wanted to say on this was to turn back to the question of the expert and whether there was any support for the court's conclusion about the value of the apartment. It is telling that my friend on the other side cannot point to a part of the record. I think the most relevant part of the record is in the appendix at 81 to 82, where you have the court give a brief colloquy with the expert. And I think what's important to recognize is there was a second claim involved at the trial court. The tenants also claimed that they could get their security deposit back for the month of July before the replacements would have been renting. So they said, well, it wasn't fair that you landlords tried to get $3,500 a month in your advertisements. And the response to that, the landlord's response was, well, maybe we could have. You undercut us by trying to do it at 31. And the trial court found against us. We do not appeal. So that's done and settled. But the reason I bring it up is the colloquy at 81 to 82 between the judge and the expert was about that question, was about the effect of the tenant's advertisements on the landlord's efforts. It was not about whether the rental at the end of the term had the replacements been accepted would affect the value. That was just not what was discussed. And so to the extent, I mean, as the court reviews that, I think it's very clear in that context that there's just no support there by the expert for the magistrate's conclusion. If the court has no further questions, I think we've covered it. And so we would ask the court to reverse both the judgment for the landlords and the denial of summary judgment for the tenants on the mitigation claim, and reverse and remand the dismissal for further proceedings on the CPPA claim. Thank you very much.
Thank you, counsel. Thanks to you both for your time. The case will be submitted and this court will stand adjourned.
This court is now adjourned.